In today's video, we're going to talk a little bit about licensing a patent. So if you have already filed for a patent application and you got a patent issued, a lot of people come to us and ask, what are the things I can do in order to license a patent? Hi, my name is Juban, and in today's video, we're going to cover the idea of licensing a patent. Before you go in the path or down the path of licensing a patent, one of the things that you need to be aware of is what are patent rights? Patent rights are negative rights. It's what I call negative rights. They are not the right to do something. They are the right to stop others from doing what is in your patent. Why is that important in the context of licensing? Because there are three things that you can do with your patent in terms of licensing. The first one is you can license someone to make the product. The second thing is you can license someone to use the product or the idea that is patented. And then the third thing is you can give someone a license to sell a final product that includes your patented idea. So you can make, use, or sell your patented idea through the patent rights granted to you. Now, the licensing portion of it is a contractual relationship between you and somebody else, whether it be an individual or a company, that basically outlines what patent rights you are granting them. Remember, patent rights can be exclusive, so you only are going to give it to one person and nobody else. Or patent rights can be non-exclusive, meaning that you're going to give it to a bunch of different people who could be competitors to one another and who could be in various different lines of revenue. Now remember, we had other videos that talk specifically about what revenue patents are. A lot of patent attorneys fail to take into account your revenue stream when they get you a patent, so they've only protected your idea, not your idea in the context of your revenue stream. So you're ready to license your patent. You've decided whether you're going to license someone exclusively or you're going to do non-exclusive. There are other restrictions you can put on your license, which again, remember, is a contractual relationship. So the first thing is it exclusive or not? The second thing you look at is whether or not it's geographically limited. So are they only allowed to sell it in certain territories, such as pick 5 states or 4 states, or are they allowed to sell it across the whole country? Remember, patent rights are by territory. They're not patent rights that are worldwide. So if you want to enforce a patent in the US, you have to have a US patent. You can't take a US patent and try to enforce it in Canada. It doesn't work that way. You have to have a patent issued by the Canadian government as opposed to a patent issued by the US government. So you've decided whether it's exclusive or not. Number 2, you've decided geographical limitations. Again, that's within the United States, what territories they can act in. And then the third thing is whether or not your license is restricted to one of the 3 areas: making, using, or selling. So that being said, you can take a look at your idea, take a look at your revenue stream, if that was taken into account when you got your patent, and then move forward and decide how you're going to go about licensing it. The more work you did up front in terms of getting your patent and making sure it's protected the revenue stream, the easier it is to come up with the licensing terms. That's it in a nutshell. If you have specific questions, give us a call. We'll be happy to go over it with you. Take care.